Tonight, you can see we're talking about wills and probates. Who gets it when I'm gone? And we have a few online. Please feel free to join in or ask questions as we go through it. I usually like to answer the questions as we're going, but we'll also have time at the end, hopefully, for a few questions if need be. So tonight, what we're going to take a look at is a few areas. We're going to start off with some basic terminology. I'm not going to go into a lot of it because there's a lot of terminology that's used in probate. I'm just going to highlight a few of the words that you may not realize are there or what they would mean as you quickly look at them, and some of the ones that you're going to encounter real often. We're going to look at the probate process. How does it get started? What's involved? How does it end? We'll look at then, and we'll spend most of our time on probate case files. What can I find in the typical probate record or wills? And how to analyze those more carefully, perhaps. And I'll show you a bunch of examples that I hope will highlight why it's important to look at every single piece of paper in the probate file, not skip over some that you might have thought, oh, that can't be important. It might be. And then finally, how to find probate records. That's what you all come for, but we're going to spend most of our time trying to convince you to use them tonight, because they are one of the most valuable genealogical records available to us. Not everybody has a probate, sadly. If you didn't have property, chances are you didn't have a probate. And even people who did have property, sometimes they didn't end up in probate. So not everyone's going to have it, but it's worth trying to find out if they did. It's worth the search, because if you find a probate file, it's gold, truly gold.
And if you're living today, it's probably better to get a trust.
It's easier. It's easier today with a trust, there's no doubt. But trusts don't get filed in courts. Consequently, if somebody did a trust, you may never find it, or their will, because you don't have to probate a will if there's a trust. So, yeah, you bypass the courts entirely, or potentially entirely, if you have a trust set up. All right, so fortunately in the 19th century, they didn't have trusts. So we look for probate records. Well, some of the terminology that I want to familiarize you with, and I've put these terms that are in the, on the slides in your syllabus tonight. Relic, this is a fun one. A relic is the widow of the surviving spouse, but sometimes in some of these older archaic use of the words, relic was referred to instead of widow. And like, it was more often the widow rather than the widower.
Right.
Yeah, yeah. It's just like,
men held
yes, yes. And consort, same thing. Only in the case of the use of the word consort, it usually implied the man or the testator was still alive, if it was written in a legal document with consort. So I wanted to familiarize with the use of those couple of words. The issue is just like we used in genealogy, the issue of a couple, their children. Issue, when used in a legal document, usually, however, refer to any of the direct descendants, children, grandchildren, etc., as opposed to nieces and nephews and siblings. The term infant, this is a fun one. You see this in probate documents. Infant doesn't mean an infant the way we use it today. Infant meant any children under the age of majority, or usually 21 in most states. So don't assume because the word infant appears that that was a small child. It doesn't necessarily mean that in legal terms. The executor, male, executrix, female, same with administrator and administratrix, male and female. You'll see those words used quite a bit. I think those are pretty self-explanatory. Executor was the term if there was a will and the testator assigned who he wanted to take care of his estate. They were called the executors. If the court appointed them, regardless of whether it was a will or not, if the court appointed them, it was an administrator. That's the difference between the two terms. The legatee, this is a term that you're going to run across periodically in these. These are the persons designated to receive the personal property, personal as opposed to real estates. When we have a devisee, the devisee is the person who receives real estate property. Now, Do we see those? I see legatee all the time. Every once in a while, I'll see the word devise, which is the verb, and devisee, the person who received it, but not as often as you will legatee. And then finally, we're all familiar with the last one, the surety, which is the bondsman, the person who's going to guarantee that the administrator does everything the court demands and doesn't abscond with the property himself or herself. Now, those are the people involved. The assets have some unique names. The missuage was, excuse me, oh, I switched. Back up here, I went too far. Oh, back.
So these are French words, is that?
Yeah. Some of them are, absolutely. The missuage was the dwelling or the buildings on the property, as well as some of the adjacent land to the buildings. The moiety was typically a part of the real estate, usually a half, when they talked about a moiety. The chattels, you're probably familiar with that term. That's the personal property. It can be the livestock, it can be the equipment, it can be the furniture. It's the personal property of the testator or the deceased individual. The appurtenances, the rights or objects belonging to the property, like the right of way. So if there were roads, if there were passage, if there were trails, that refers to those pieces. And then the dower, I think we're all familiar with that word. The legal right of the widow, what they were entitled to under the law. Now, sometimes the widow would waive their dower, even in the inheritance. If the will did not specify what the dower law said they should get, the wife or widow in this case could waive their dower in place of what was in the will. But the judge will usually want to clarify that, especially if the dower right would have given them more. And so the judge is going to want the widow to say, okay, I'm waiving my dower right in lieu of what's in the will. And then the legal process. So the imprimis, you'll occasionally see that in the wills, and that usually refers to the starting point of the list of bequests. Sometimes it'll be, however, put right at each bequest to each individual. And it's oftentimes not spelled out in the entire word. It's usually abbreviated IMP. So be aware of that. That's the common abbreviation for that one. The non-cupative will is the oral will, usually a deathbed oral will. Whereas the holographic will is the entire will written out in the hand of the testator. Well, a lot of them couldn't write back in those days, so you don't run across a lot of those, but every once in a while you'll find one. And the easiest way to know it is to compare the signature to the rest of the handwriting. If the signature is different, they didn't write their own will, which was often the case. A codicil, not all wills are going to have codicils. Codicils is the afterthought, basically. I want to change just a part of my will, not the whole will. And so they'll add a codicil. And when they file the will with the court, they have to file the codicils with it. Intestate and testate, died with or without a will. Intestate is without a will. Testate or testator is the person who dictates the will. Devise, to give real, is a verb in this case. They devise their property. They give their property. Bequest is their personal property. Their real estate property versus their personal property. Just like the devisee was the person who received personal property. So those are some of the more common or unusual terms that you're going to run across in probate wills. There's a whole lot more. I've given you on the slide here and in your handout one reference. It's a very shortened list of legal terms that are used primarily in probate. Of course, you can always go to Black's dictionary, or Bovier's that I gave you last time, and I've given you those links again so that you'll have them regardless of which syllabus you're looking at. So let's talk for just a minute about the process then. How does all of this happen? So it starts off with a petition to the court. Now, if they died intestate, which a lot of times is what happened, somebody petitions the court to appoint an administrator. It can be family members who want to get things rolling to get their inheritance, or it can be creditors who say, I want this bill paid, so I need somebody who can pay the bill. So either one can actually petition for an administrator to be appointed and a probate to be started on a case.
I have a personal situation where it was an attorney
Well, yeah,
that went to the
nowadays.
judge. Someone died, a relative died with no will, and it was discovered 9 months later.
Oh, yeah.
And because mail was being returned, and so an attorney went and
Yeah,
was appointed.
nowadays usually that's the case, but
Yeah.
oftentimes it was the creditor themselves went and
Okay.
petitioned the court rather than their attorneys. Oftentimes when they did petition the court, they also specified who they wanted to be the administrator, especially with family members, but even with creditors, they could specify a particular individual that they were petitioning the court to appoint. Now, in the case of family, that if they petition for a specific administrator, oftentimes that administrator is either a relative or a close family friend. And so they belong on your cluster list, your family's friends, associates, and neighbors, your fan club for that deceased individual. And it might be worth trying to figure out what was their relationship to the deceased for them to have been, for the family to have asked for them to be the administrator or to be appointed in lieu of an executor. If they died with a will and the named executors all decline the job when it comes to the court, then the court appoints an administrator. But typically it's still going to be likely a family friend or somebody the family recommends. So that's how things get started. They petition either to prove the will if they die testate, or to appoint an administrator if they die intestate. Now, as part of proving the will, there's some other steps that get involved. The court has to hear from the witnesses to validate the will, to ensure that the will was written not under duress, that the man was of sound mind, that all the legal parameters are met. And so there will be other affidavits included as what the witnesses' affidavits. There may be a widow's affidavit. Depends on how extensive they have to get in proving the will. Whether or not the will is contested will be included in there as part of this initial proving the will. So there could be a lot of documents involved with a will other than just the will itself. And if there were any minors, guardians have to be appointed. So there's going to be guardianship records. If there's going to be a surety, a bondsman named and guaranteeing the bond would be paid in the event that the administrator drops the ball. Once all of that has happened, the probate case is opened, and it could go on for years and years and years. And we're going to look at an example of that. Then the first thing that has to be done is they have to inventory the estates. They have to and appraise. Now, usually the court appoints who's going to do the inventory and appraisal. But there again, they're probably friends, neighbors, associates of the deceased. These were small communities, generally speaking, and so you can assume that they may be related or they may know each other. But the court does appoint those, and the family doesn't usually petition for particular appraisers to be named. The inventory can be fun, and we'll look at an inventory because this is everything he owned. Everything he owned. So you get a good feel for the family, for the individual, for how well off they were or not well off by that list, that inventory list. The administrator also has to then notify beneficiaries or potential beneficiaries. In the case of intestate, all potential heirs at law have to be notified. And a list of those have to be created for the court. So that list will show up usually in the probate records. The creditors, somehow the creditors have to be notified, and they have to be given a time period in which to file their petitions, their requests for reimbursement. We're going to look at some fun ones of that. The administrator then has to pay those debts, has to somehow come up with the cash to do that. Now, oftentimes it meant selling parts or all of the estate to fulfill the financial indebtedness of the individual. It had to pay administrative costs, had to pay the taxes, had to pay the appraisers, had to pay the widow, had to pay everybody. So there was a considerable amount of work involved in being the administrator or executor. Finally, after all that's done and whatever designated time period the court has set has elapsed, they can distribute what's left of the assets. Now, the fun part is, what do we find in these files? So let's spend some time looking at probate files and the contents of probate files. There are a number of different kinds of documents that you may potentially find in a probate file. And this is just a brief list of the headings of the kinds of documents you might find. We're going to talk about these individually as we go through this. So let's start with the petitions and what are the value of a petition. On the right-hand side of the screen here, you see a petition, and I'm going to just blow that up here and show you the transcription that I made of this. In this particular petition, as you look at it, you see it starts off with a date. This is the date of the petition, May 25th, 1866. John Finch, deceased on Wednesday, the 23rd day of May, INST, stands for instant. Again, lots of abbreviations show up in these records, and so part of the struggle can be just figuring out what do the abbreviations mean. What does instant mean? That's a term I didn't give you. Does anybody know? So the legal definition in this case is instant meant the same month or same year and at this same time. So what does that tell me right off the bat? It tells me that John died on the 23rd of May, 1866. Just 2 days before the petition went to the courts. They don't always happen that fast. Remember, courts weren't in session all the time back in those days. Maybe they were quarterly courts. So you can't assume by the court date that the death occurred in the last few days. It could have been the last few months. But this one, it does tell us right off the bat, he died just 2 days before the petition. And we whose names are hereunto subscribed request the appointment of Daniel Bradbury as administrator, as to take charge and settle. Now you'll notice in my transcription, settle is S-E-T-L-E, and then sick behind it. When you do a transcription and you're afraid the reader might think you've just mistyped it, you put the term sick behind it to say this is the way it was spelled in the original document. So that's how they wrote settle. His personal effects, he having died intestate, so we know there's no will to go looking for, leaving personal property. And then the names of 3 individuals appear at the bottom, plus George Finch, Melinda Bowman, and Waldo Finch. Now, the Finches obviously are related to John, you would think. Who is Melinda Bowman? Well, it turns out that these 3 individuals, as we work through this, are the 3 eldest children. The other children are minors. So these are the 3 eldest children petitioning the court to set up a probate for their father. That was the petition, that little piece of paper. If they die testate, as you can see, you can't read this, and I didn't think you would be able to, but this was a will. So this is the last will and testament of John. Let me see if I can blow mine up and read it better here. Tittle. And so that's the document that they bring to the court if you die intestate. Remember, wills were kept at home typically or in some safe location. And they don't show up in a court record until somebody brings them to court to prove the will. So they're not just on file waiting for you to die. So I blew it up a little bit Oh, no, I didn't. This is a different document altogether. So this is the probate of the will. So once a will comes to the court has to talk to the witnesses. And so this was the affidavit of the witnesses, validating that they, in fact, were present when he signed it, that he acknowledged them as the witnesses, that he was of sound mind at the time of his, all of this is in their affidavit. The judge asks all of this to make sure that will is going to be valid. So they present all of this in their affidavit, and you can see their signatures at the bottom are the same signatures that appear at the bottom of the will. So the two witnesses have testified now. Now, in the case of this will and the probate of the will, the dates conflict. When I write my citations, as I've shown at the top there, I always include two dates. The date the will is signed, which is going to be somewhere in the will document, and the date it is proved. Why do I do that? So the two dates were 29 June 89 and 12 March 90. So there's about a 9-month gap in there. Why have I done that? Well, because if I can't find any other death date, I have narrowed the death date down to sometime between the time he wrote his will and the day it was proved. So I've got it down now to a 9-month range for his death date. That might be as narrow as you can ever get it. That's what you document for his death date, and you explain what those dates represent when you do that. In this particular will, what he left his wife, what he bequeathed his wife, was different than what her dower right was. So now the judge asked for the wife, Carolyn Tittle, to verify for the court that she was willing to accept the will as what she has bequeathed, rather than her dower right, to waive her dower right. So that's another affidavit that now appears in this probate record. Those aren't always going to be present. If there's not a conflict, or if the will is more generous than the dower right, it's not a problem. Then we get a document in this same probate that starts off in the matter of the estate of John Tittle, deceased, probate of will. So here what the court has done is basically explained their legal position and said, I've reviewed the witnesses, I have talked to the widow, there's nobody who contested the will. The will has now been accepted and proved. And so this is the judgment, basically, of that the will has been proved. Now, sometimes that simply takes the form of the letters of administration, where he says, okay, it's been, or I'm giving you this, that I'm satisfied with all the information I have, and that I'm assigning this administration to so-and-so. So just in the petition to get this probate started, you have a number of different documents that might show up. And sometimes those documents include relationships, and sometimes they don't. But you've got a lot of names of potential people that need to be looked at as part of this probate process. Now, the will was a very formal document, and there were specific parts to a will that were supposed to be included. So I wanted to give you just a quick rundown of what you expect in the will. Typically, the will starts off with an invocation. Is it always there? No. Sometimes it's forgotten. Sometimes it's an indication of their religious beliefs or non-belief, if they omitted it intentionally. But if they included it, it also gives you a little bit about their religious belief. They included that invocation at the beginning of their will. Identification of the testator, I, Joseph Trichler. Typically, the testator will also include something about their physical and mental status. It was not uncommon for him to say, being weak of body, but sound of mind. Saying, I realize I'm dying, but I'm coherent enough to tell you what I want. That's right, I know what I want. They typically included this comment or statement as the first thing before they go into any bequeathing to pay my just debts, pay for my burial, and burial instructions were commonly included in this part of it as well.
The standard wording is including a headstone.
Yeah.
Yeah.
Not always, but yes, it could include that. Sometimes it's just commit my body to the grave.
Yeah.
But it often said something about their burial and pay the debts. Then, after they've taken care of all those initial formalities, they start their list of bequeaths or devises in the case of some wills. So, who do they want to have what? Now, the nice thing is they typically number each bequeath, or they'll put the word item, or sometimes they'll put IMP. So they separate the bequeaths by individual, typically, with some designation for you to look for. Then toward the end, typically they'll name their executor or executrix, and there can be multiple people. It's not uncommon for it to be 2 or 3 people that they name. Better that they name several, because not all of them will typically want to serve. And it's not uncommon for only 1 or 2 of them to actually, for the court to appoint only 1 or 2 of them, of the 3, because somebody turned it down, said, I don't want to do this. It does oftentimes identify the relationship to the individual, as we'll see in some examples here. And revoke all previous wills. Even if there wasn't a previous will, that statement will be in there, just in case somebody comes forward and says, oh, I have a will. No, the revocation was included. The date, of course, is added. Sometimes it's the beginning, sometimes it's at the end, sometimes it's at both. But look for a date. There's going to be a date typically in there. Signature or mark if they couldn't sign. And if it says mark, again, probably that tells you a little bit about their literacy. And then the names of witnesses. Now, I have seen wills where the witness section was created and no names appeared. So you're going to see exceptions to all of these things as you encounter or look at probate records and wills. Codicils, I don't find a lot of codicils typically, but every now and then you'll find a codicil, and it usually appears in the court record right there with the will. So here's a will. I'm going to blow it up a little bit. That I have as an example that we thought we'd take a quick look at. In the name of God, amen. So there's the invocation. I, Abraham Bledsoe, being in, let's see if I can blow this up a little more. Oops. All right.
Where's that thing that converts it?
All right. I, Abraham Bledsoe.
Being very sick and weak.
Thank you. Yeah, sick and weak, but in perfect sense and memory. Got to tell the judge, I know what I'm doing. Blessed be God for it. Do make and appoint this my last will and testament, revoking all other wills and all of my estate that
That God has
blessed me with, do leave as follows. All right, and then he says, and then you'll notice on the lines that follow, item, 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 item. That's each person that he's bequeathing to. He says, item, I give and bequeath to my well-beloved son, Isaac Bledsoe, 5 shillings sterling. Item, I give and bequeath to my well-beloved son, Abraham, 5 shillings. The next one is Thomas, 5 shillings. And goes on until he gets down to about the 5th one. It says, Moses, my land and plantation whereon I am now living. Moses gets the land. Everybody else got 5 shillings. Unless, and he goes on, unless something happens to Moses, and then he says the land is to be divided among all the others. So he does look forward to something else happening. So He made it very clear, item by item by item, made it very easy to read through and identify all of the individuals and their relationship to him in his will. And down at the end, lest we not forget, he gives to his wife, Chloe, down here. Oh, Sarah. To my wife, Sarah, executor of this will. She also got some materials or some part of his property as well. So he identified his wife, Sarah Bledsoe. Then he goes on, this is a different one. This is Thomas Barnum in Pompeii, and I did Thomas's here because you'll see things crossed off. Remember when they're crossed off, there was an oops. Typically it was the court's oops because this is from the court records. They are copying the will. These are not the original wills that you're looking at when you look at court records. They're what the clerk copied into the court journal typically. Now, does that mean the original will is gone? Not necessarily, but it's going to be filed with those loose papers we talked about in court records. All those documents that, so unless you get access to the loose papers, you may not ever see the original will, the original itself. So when you see things crossed off, it's usually because they realized they were copying something. They got off lines, or got off track. So skip over what they crossed off, but look at it. And in this case, as you look at it, you'll see he originally, in the crossed off part, he lists somebody who then gets listed later on. He just had jumped ahead as he was copying this and he skipped. Ideally, and I've seen this, try to find the original. It is hard and you oftentimes can't. And compare them. You will find mistakes in the court journal copy versus the original. So sometimes they catch the mistakes, as in this example, sometimes they don't. So don't stop looking just because you found the court journal copy. And then in this case, it goes on some more. Page after page, he goes on and on. It says, this will turned out to be like 3 or 4 pages. And he eventually gets to this. First, I hereby. And he names his first bequeath to my son Thomas. And as you go through this, second, he still itemized it, but he didn't do it line by line. Second, I bequeath to my son, and then he starts the crossing off part. So you have to jump ahead and discover he's talking about Isaac for this second one. And then he jumps ahead to third. And this is Morris, who got the name that got crossed off in the first part. So now he's listing Morris as the third beneficiary. And you can go through and find item by item by item. He just does it with numbers. First, second, third. Going through here. Now, as you're going through, you're trying to make a list of all these relatives. All of these people and what their relationships are to the testator. And it goes on. And next page, and on, and next page, and on. Finally, here's his signature down here, and the witnesses, and the statements for proving the will. As I went through and with pages and pages of this will, I came up with this list of relatives of the testator. So he named a number of people, including 4 of his grandsons, Charles Delos, Thomas, and who were sons of Isaac, he said, and Miles, son of my deceased daughter, Electa. Now, in his will, Isaac received an inheritance. Remember, Isaac was listed as the second item. But he also named his grandsons, sons of Isaac, in his will. When the will gets proved, Isaac is dead. So you will pick up those subtle differences by comparing the original will to the proof and to the statements of testators later on. So typically it would have gone to Isaac's children. Isaac's portion in the will would go to his children, is the way it works out. Because in the will it usually says Isaac or his heirs. It's often the way it's written. And then any codicils just get added as an addenda to the will, basically, any changes. So go through the codicils carefully and see it's not the whole will that changed, it's just pieces of it that changed. So always compare the codicils to the will as you're examining these documents. Now, they petitioned the court, they had appointed administrators, bonds get set. If there are guardianships, bonds get set for each of the guardianships. Now, what was the purpose of the bond? Did they actually collect money? No. 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 The court didn't collect anything. All the surety was a guarantor saying, in the event that the testator doesn't do their job to the satisfaction of the court, that they would put up the money for the difference, for the losses. So how much was the bond? The bond was typically at least the value of the estates, and usually a little more. So back in the 19th century, it was usually somewhere between 100 and 200% of the estimated estate value at the time they set a bond. So you get a little bit of potential awareness of the value of their estate from the bond amounts. Now, in the case of guardian bonds, the guardianship bonds typically were based on the age, because they would remain the guardian of that individual until they reached the age of majority rather. And so that was oftentimes 21. So how old were they at the time? Had something to do with the bond. Or what were the expected expenses for the raising of that child? So no money actually changed hands. It was simply, today our bondsmen work similarly. There's usually a small amount that gets given to the courts, but not the entire bond, typically. 10% or whatever percentage the court requires of the bond. But in those days, nothing actually got transferred as part of this. Now, can the bond records give me any details about the family? Absolutely. So here is from the Court of Common Pleas, appointment of an administrator for the estate of John German. And it says, upon application, Sally German and Michael Kister are appointed administrators of the estate of John German deceased, and ordered that they give bond in the amount of $500, and John T. Kister and Joseph Kister were accepted as the surety. And Joseph Wykirk, Samuel Elder, and Tobias Archie are, cross off, appraisers for the personal property of the deceased. So the deceased appears to have died intestate, because administrators were appointed, one of which looks like might have been his widow or a daughter, perhaps, but somebody other than, we don't know the relationship from this particular document. Guardianships. Part of the initial petition for guardianships for any minor children. This same probate file, as Susan German being appointed administrator, had several guardianships that followed the appointment, the letters of administration. And so the first one here was William Everett, appointed guardian for Benjamin Sherman, minor age, and I think it says 3 years, and Catherine German, age 7. These were minors. Chances are they're the children of the deceased. So, but they could be heirs at law, not necessarily children. Any heirs at law will also have to have guardianships appointed if they're minors. So there we have 2 children, potential children named in this one. Right following that one was another one. Enoch German, minor, age 17, and Lucy German, minor, age 14, chose Michael Kister as their guardian. Chose. Children of a certain age were allowed to choose their guardian, and usually that age was 14. Usually, but that again is determined by state law. Remember, probates are governed by state law. So as you are studying a probate, as you come up with questions about, well, why was this way? Or who were the heirs at law? Check the state probate law. Check the state probate. Another one, Conrad German is appointed guardian for Louis German, an 8-year-old. Conrad German. So he has to be old enough to be a guardian, so he's got to be over 21. Is he an older brother? Is he an uncle? We don't know, but probably a relative based on surnames. We saw that there was a 17-year-old, so Conrad could be a sibling, an older sibling. John Kister appointed guardian for John H. German, age 5, and William H. German, age 9 months. So he had some young children, it looks like, at the time of death. Joseph Kister appointed Adwin as a guardian for Adwin German, minor, age 5. Nathan Kister appointed guardian for Harriet German, minor, age 11. Well, look at all of these guardianships that were records that were created in this probate file. And as I go through and list and get together, I come up with quite a list of individuals from just from these guardianships and who their guardians are, and the ages were all given. And we still don't know what the relationship was for Sally German. We know who the deceased was, of course, but we can probably assume, given all the rest of this, probably a wife. That's what I'm going to be looking for as a relationship. We don't know who Michael Kister, the other administrator, was, and we don't know who all these other Kisters were. Chances are relatives, perhaps her brothers. Perhaps. So it gives you some hypotheticals that you can use as research questions now to try to build this family structure. Letters of administration do sometimes contain some helpful information. Now, this is simply from an index. Indexes are not our preferred record, but if it's all you've got, you go with it. So we have the index listings here of individuals who are named as received letters of administration for the various estates. Sometimes you can tell things from the names that may give you some clues to work with. Actual letters of administration were awarded by the courts, and usually that's what you will find in the probate record. So here's an example of a letter of administration. The territory of Missouri, county of St. Charles. And it says, be it remembered that on the 6th day of October in the year 1817, Anthony Bludso made application at the office of the clerk of circuit court for letter of administration. So he went and applied himself for a letter of administration on the estate of Loving Bludso, his deceased father who died intestate. Well, we've got a relationship now between the administrator and the deceased. And then it goes on, which on the said Anthony Bludso, and I couldn't make out the word entirely, and with Jacob Harst and Preston King, his sureties, for $1,000. So I've got an estimate now of what they thought Loving's estate was worth. Condition as the law directs, and
this is actually from an index. Indexes are not our
someone needs to turn off their microphone,
but
please.
if it's all you got, go with it. So
Microphones.
we have the index list here of individuals who are named as received letters of administration for the various.
Thank you. Condition as the law directs and taking the oath required by law, letters of administration are granted him, meaning Anthony got his request, and then the appointed appraisers are set. So sometimes the letter of administrations do contain relationships that can be useful for you. Here's another one. This is a copy of a letter of administration in the court records for the estate of David Barnard, late of Sullivan in the county of Madison, and this is New York. So now I have the name of the deceased and where he last resided. Helpful information for doing research. This Letter was recorded September 15th, 1808. The people of the state of New York, by the grace of, oh, I mistyped that, grace of God, free and independent, to David Bernard and Pardon Bernard send greetings, whereas David Bernard, the deceased, having whilst living and at the time of his death, goods, chattels, and credits with the state, by means whereof the ordering and granting administration of all and singular the said goods and chattels and credits to David and Pardon Bernard. It doesn't tell us the relationships of David and Pardon to David Bernard, but they have the same surname. Oftentimes it was relatives, and oftentimes it was members of the family. So probably sons, especially since David and David are both named. Probably this David, the son of David, and Pardon is probably his brother. So you don't always get relationships explained, but the names can give you some hints, some clues. Look for those kinds of things. The record can be loaded with affidavits. From the minute the petition is made to the end, you can have affidavits, simply testimony of one person or another about one issue or another dealing with the probate. And these can be very useful and valuable pieces of information. So here is a affidavit by Thomas Barnum. We talked about Thomas earlier when we looked at his will. Had that big long list of children named and grandchildren named in his will. So here is an affidavit now in the matter of proving the last will and testament of Thomas Barnum. We looked at his will, now the affidavit. Thomas Barnum of the town of Pompey in said county, being duly sworn, says that Thomas Barnum, father of the deponent. So Thomas Jr., for lack of, it's not in the document, but the first Thomas is the deponent. This is his affidavit. He's making these statements, and he's saying right off the bat that Thomas Barnum Sr. is his father. Then an inhabitant of the same town and county, meaning the two Thomases lived in the same place, died in the same place. So he died in Sullivan, and on or about the 8th day of December instant, meaning the same year and month as this affidavit. So now we've got an approximate death date for Thomas Barnum. We don't have to go with the proving dates or the date of the wills. His widow, heirs surviving, also leaving this deponent of the said county, and Rebecca Squares, wife of. And now it starts to list individuals and their spouses. And so he goes through and identifies all the family members of Thomas Barnum Sr., including the grandsons, including the grandsons that he doesn't know where they are, somewhere in Ohio, he says. He goes through and gives a great deal of detail about these individuals, who they're married to, where they live, all the kinds of heirship lists that are jewels. And so as you go through the document and extract the information, here's what I get from that affidavit. All the people, relationships to the deceased, relationships to someone else in the discussion. So the grandsons who they're children of, and where they're known to be living. Some of them are blank because they're dead. These two are deceased now. So here's where we see that Isaac is now deceased. He was in his father's will, but now he's deceased. And it says so in that affidavit. Be sure to compare it. Look for differences between what was in the will and what's in the affidavit. For example, we see that Isaac has died. Isaac was listed in the will, but now he's dead. These are fun. You know, they're crazy. The lists can go on and on and on for pages and pages, and you can't read this one, but just to show you, they go on and on. And at the end of this page, here's what the appraiser's value is for page 1. He puts that value at the top, page 2, and starts the next list. And at the bottom of this, he has a subtotal, puts that subtotal at the top, page 3, and goes on and on and on. until he gets to the end and the value of the estate of this individual. But it's just fun to find the pieces of what they owned and what was important to them, to find these in these great lists, these inventories. This is the historical part that we can bring our ancestors to life with. So, and start writing some stories about them. In this particular case, after the inventory was all complete, the appraisers, and this is usually done by law, the appraisers set apart part of the estate right up front, first right off the bat, before any creditors, hands on it or anything else, for the widow. Now, the law usually mandates that. That's their dower rights. And so the appraisers set apart what the widow gets. And so they go through and list, okay, these are what the widow's going to get, and here's the value of these things that we're pointing to the widow. And so these items are now set apart. The appraiser, or the administrator rather, cannot do anything with these things. He's saying these belong to the widow.
So what was the limitation? It didn't include everything he owned.
No. That list was much shorter than the original inventory.
How did they decide?
Probably based on what the widow needed, or in terms of her keeping her household. And they also designated an amount of money. And this is a receipt, actually. The next item here that I'm showing you is Samuel Kaufman is the appointed administrator of the estate, it says, and he is giving $175 in full for my year's support, set off by the appraisers of the said estate. And Catherine Meinhardt is the widow who signs this as a receipt for having received that $175. That's the monetary amount she gets for 1 year while this is in probate. And so these items are hers to live off of until the probate is settled, until she gets her full inheritance. So again, just fun little details about the family. This is signed by the appraisers, saying that once the inventory is done, they have to validate and verify for the court that it was complete and thorough, and this is their statement to the court saying, it's said and done. By the way, they get paid for appraising too. I didn't put the receipt in here, I don't think, but they got $1 each for inventory and appraisal of the estate. That was a lot back then, but the bond was $1,000, so it's a pretty good size estate. $1,000 back in the early 1800s. Accounts and receipts. So now the administrator or the executor, they've got to keep records, lots of records, because the court wants proof of everything. So now they posted for the creditors a no public notice. And they're going to start getting inundated potentially with invoices of, well, they didn't pay for this, they didn't pay for this. Remember back in those days when they went shopping, it was on credit. The stores, used to just keep a running tab for you. Well, now they've died, and they want payment for that running tab. So public notice had to be given. And that usually shows up in the probate files, the public notice. And so here's the public notice itself. And here is the publisher's statement to the court, affidavit to the court, that they did in fact publish this on 4 consecutive issues, and the dates and details, and then signed by the publisher. So, and they have to provide that for the court. So if we blow it up, the estate of George Meinhardt notice is hereby given that the undersigned has been appointed and duly qualified as administrator of the estate of George Meinhardt, deceased, late of Greenfield Township, Fairfield County, Ohio. Now we know where he was living when he died. All persons having claims against the estate will present them for settlement, legally authenticated within 1 year. They have a time frame. Get it to us now, or forever hold your peace. And then the administrator's name and the date. This is a list of items. So this is now the list of debts that Samuel has put together for this estate. I'm not going to go through all of them. I'm going to show you a couple of things that were kind of fun, though, in this one. The estate of George Meinhardt. You notice it's dated 1850, January 8th. And there's a bill for $10.50 for the making of the coffin. Remember, high on the priority list was pay my burial. That was specified in the will. And so here it is. But what's important about this? I have a date. January 8th, 1850. They're making the coffin. Contracted for the coffin. So probably died real close to that date. Now, I have an invoice here and a receipt of payment. This was now George Meinhardt, and this was the vendor. And on January 2nd, he charged a drink. A drink of rum for 12 cents. And on the 4th, he paid for a meal for 18 cents. So he had a tab of 30 cents with this particular tavern or pub, whatever this was, that occurred on January 2nd and January 4th, 1850. What was the date on the tombstone or on the coffin? The 8th. I've narrowed his death date down to about 4 or 5 or 6 days. So pay attention to every detail. I wouldn't have caught that if I didn't look at these receipts. Cause of death not included, but too much rum. Maybe he was a heavy drinker, who knows. Anyway, be careful about what you assume from these records, but these were dates that I can verify. And so I look at what you can get from these records. You may never, this was 1850. They weren't keeping death records necessarily in 1850 in Fairfield County, Ohio. This may be the closest you ever get to a death date for this man. Of course, Uncle Sam still wants their money, even though you're dead. So the tax receipts for paying taxes. But the nice thing I liked about this particular one, there were several tax receipts in this file. It gave me the property location, range 19, township 16, section 19. I can go look that up on a township map. I can identify where his land was. I know how many acres. I know the value, the stated tax value of the property. So again, you get lots of information from these little pieces of paper that are included in that probate file if you analyze and correlate all the data that you're getting from these. Oops. Well, at some point, the administrator has to sell all this property in many cases. In many cases, if they die intestate, so they don't know how the land is to be divided, they sold the land and they gave the cash to the heirs at law. And so you're going to end up with lists of sales of property. And so this is just a small example from one list. But it lists the item, it lists who purchased it, and what the purchase price was. And in this case, it also says a note on credit. They're going to have to get the cash eventually, but it tells you how much they collect for all these various pieces of property. And even the administrator is buying things. He's the administrator, Samuel Kaufman.
28 pounds of bacon?
Yeah, for 85.5 cents. So, again, pieces of information about the estate and what was in it and what gets sold, what happened to those pieces of the estate. Who gets them? Many times these are relatives buying these things up. Many, many times. Well, after all that is said and done, and that's a lot, and it could go on for quite a while, it's time for the final settlement. What did I get from this? From my great uncle's death, depending on whether I was an heir at law. So it gets divided up. Now, if there was a will, the will typically specifies who gets what and how much. But if they die intestate, then the court, the law dictates. Then you really want to go and find those probate laws to understand how and who qualified for things under the law. So here's an example of one that actually died with a will. This is the will right here of Farrington Barraclough. And Farrington died in 1861, as you can see from down here in the citation. His will was dated the 27th of August, 1858, and the will was proved on 16 December, 1861. So he died sometime in 1861. That's all we know from his will and the proof of that will. But in his will, he made some interesting statements. I give and devise, so it's property, all my property, both real and personal, including money on hand, or due me, anybody who owes me money, to become due to me, or becomes due to me, to my beloved wife, Elizabeth Barraclough, for and during her natural life, and confer upon her the right to use any part of my personal estate, including money on hand or due or to become due to me, or the interest thereof, for her maintenance, support, and comfort. Third, at and after the decease of my said wife, and after payment of any and all her debts and funeral expenses, I will devise and bequeath my real estate and the residue of my personal estate to the person or persons who at my decease, if my said wife did not survive me, would be my legal heirs or heirs. He doesn't name anybody other than his wife. Now, what does that imply? And then he just says the rest goes to my legal heirs. What does that potentially imply?
That they had no children.
That they had no children, potentially, or living children anyway. But even if they had children and the children had children, those would typically be named as heirs. So no issue in the general use of that word. But he recognizes that.
What would they do with the stuff?
So now you need the law. What does the law say as to who are my legal heirs and heirs? Heir and heirs. So he died in 61. Well, his wife lived to 1879. So this probate started in 61 and is still running strong in 1879 because she's still alive and still using his property. She dies.
So it's still considered his property?
Yeah.
Even though,
Yeah.
Yeah, because he didn't.
He only gave it to her for her natural life.
Yeah,
That was a condition in his will, for her natural life.
so it didn't become hers, she's just using it.
yeah. Is that common, or was it common?
It was because back then women didn't own.
Yeah.
Yeah, it wasn't common for women to own. Yeah. And you'll see that in a lot of wills.
Yep.
That the wife, for her natural life, and then it gets to go to the children. Yeah, you'll see that in a lot of wills.
So if it doesn't say for her natural life, if it just says to her,
Then it's hers.
then she owns it.
She could own it.
She could sell it.
She could sell it and do, well, she can anyway, because he said she could do whatever she needs to with my real and personal property for her maintenance.
So she could sell it.
She could have sold it. She didn't, but she could have. So, in 1880, February 4th of 1880, this petition for partition of the estate of Farrington Barraclough appears in the court records. So what happened now was his heirs at law, now that she has died, petitioned the court to partition his property among the living heirs. Of course, they have to identify who those are. So here is a list, 2-page list,
That's a big list.
over 100 names of heirs at law for his property. Over 100 names. Now, this document is wonderful
That's why.
But who are these people and what makes them heirs at law?
Right.
That's the question you have or should have. So you go through and start reading the documents. And you get to this place that says petition, charge, and represent to the court that the said Henry Barraclough, Marabella Hannah, and a bunch of names are listed in here. Let me turn my pointer on so I can show you. So the names go on and on and on here. Are the nieces and nephews and next of kin alive at this time to Ferrick Barraclough deceased, and that the said Farrington Barraclough died in 1861, which we knew, leaving surviving him neither child, father, mother, brother, or sister. All of his closest relatives who would have been the heirs at law had already died at the time of his death, it says. None of them survived him. And none of kin to him, but the children and descendants of one sister. They're dead, but these are the descendants now of one sister, Anne Oglever, and three brothers, David, Henry, and John, all deceased. So we're their children. We are the children of his brothers and sister.
Yep. Yep.
And we want our piece of the pie. So, what do we learn? He died, that he had no living children when he died. It says it right here. Nor mother, father, brothers, or sister. Only one who survived him was his wife. And once she died, this petition to partition his estate was filed with the courts, listing lots and lots of nieces and nephews, the children of his siblings.
But if he had deceased children, wouldn't his grandchildren be?
If he had deceased children, his grandchildren, so they're not listed.
They're not listed.
So either he had no children, which is likely, or they didn't have any kids, none of his children did. None of them survived, right. All right, so now I went to Family Search Family Tree when I was looking at this will and said, well, let's see what Family Search Family Tree says about him. So here's Ferrick Barraclough and his wife Elizabeth, but look at this long list of children listed for him, all of which have death dates after him. And when down here with a death date after him, guess what? Family Tree is wrong. Whoever put this together hasn't looked at his will and probate. And I've put that comment in here now saying, excuse me, he didn't have any kids. No, here's the sister Anne, and his three brothers are listed here as his siblings, but these are not their kids. And we don't know who this Mary is, whether he had an actual first wife and whether these were her children from a previous husband. We don't know. But they're certainly not his children because his probate says he had no children.
So don't believe everything you...
Don't believe everything you find on Family Tree.
Yeah.
Verify, verify, verify.
Do they have any sources?
No. Oh, a couple, but nothing useful. Yeah. So, always don't rely on what you find on family trees of any sort, whether it's on Ancestry or on Family Tree, Family Search Family Tree. Go to the sources. That's the message I want you to get from all that. All right, well, let's quickly talk about where did I find all these records. When you're looking for probate, there are two places you want to search. You want to search them both. You want to search Family Search and you want to search Ancestry. You search them both. Why? Because they don't have the same records. And they can both have records for the same person, but the records are different. Some of them have part of the probate, some of them have a different part of the probate. So go to both, search them both. Always, always, always. To get a more comprehensive probate package that you put together on any individual. Now, in Family Search, it's real easy. Well, I mean, as easy as it's going to be. You go to Search menu at the top. This is the first page of Family Search. Go to the Search. Go down to Catalog. Yes, we're going to use full text. Always, always, always do both. But I always start in Catalog nowadays, and I'll show you why. So click on Catalog, and when you do that, start typing in your location where he died. His death location isn't always where the probate is. If he died in Ohio and owned property in Pennsylvania, probate will be in Pennsylvania.
Yeah.
So always discover where he lived and where he moved from and to, and check all the locations. Because his probate, he could have more than one probate, and it could be in multiple states. But we searched for one here. Once you come to that first page, it's lots and lots of categories. So scroll down till you get to the probate records, and right below that's going to be probate record indexes. Search them both. Probate records and the probate indexes. Well, here's the first part of the probate records available for this county. And scroll down some more, and there's more records. And scroll down some more, and there's more records. You know, there could be lots of records. You can narrow it down oftentimes by dates. You know, if it doesn't fall in the date range, that record's not going to help you. But you can narrow it down, but search all, because sometimes the records are divided up. They have a different set of records for guardianships, and a different set of records for letters of administration, and a different set of records for inventories, and a different set of records for wills. So you might have to look at multiple different records to get the complete picture, to get all the available records. Search them all. So I went to wills, the last one there, and clicked open wills. Again, you may have pages and pages. Here's just the start of it. As I scroll down, here's more wills, and now I can start looking by date and pick out which wills I want, but there were indexes as well for the probate. So I might want to do both, do the indexes and the records. The reason I go to the catalog first is here's the microfilm, so I can look at the microfilm itself and the actual records. But here's the icon for full text search. I do both. Full text search doesn't always find everything. Yes, I'll start with full text search so I know whether or not there's records there, but then I'm going back to the original film and I'm going to start looking at that film to see if there's any other records that I needed to have as part of this. Oh, last one down here. Remember, look down here, there's more pages. So don't, and I've seen ones where there's 30 pages. So always look to make sure you're checking all the records. Family Search Wiki, I do usually look here only because Family Search Wiki will usually list probate records, and not just from the Family Search site. They list ancestries, they list other sites that have records, probate that they have found, online records. So search the Family Search Wiki and see if they list any other records that you need to look at. Ancestry is done similarly. You're going to do a general search. And when you search, you're going to go all collections. This is all pointed out in your handout. Now, in all collections, you have a couple of options here. It divides it up on the right-hand side by the record types. And as you scroll down, you can come down here and find the record types you're looking for. In this case, we're looking for tax, criminal, and land records. I can click on that, and sometimes I do. Then it's going to search all the United States. Sometimes what I do first is I come over here to the map, and if you scroll down below the map, it lists all the states. And so I'll click on the state, and then I'll start that process over. This list will still be over here, but now it's just going to be for that state. Just for that state instead of all country, the whole country. So you can do it either way. You'll get to it. If you don't know what state or you're concerned there may be probate in other states for him, then you might want to do the whole country and look that way. But if it's a common name, you could end up with records out the wazoo. Look. So, you know, be careful. Use that wisely. But that's what you're looking for, is the tax, criminal, land, and wills section. That's going to be where the probate records are located. And when you click on that, it brings you to the search menu to look for records. Now, you always want to search those. Always, always, always. Didn't find anything doesn't mean there isn't anything. Not all county records are microfilmed and digitized and available. So you still want to do a Google search for the location and any probate records or probate indexes. Some counties have indexed and put online their probate records or their wills or various pieces of. So check for both the indexes and probate. If nothing else, by doing a Google search, it'll identify the locality and where you want to be looking, or where the contact is, what county office. How do I reach out to them? How do I contact them to find out what they've gotten and what I can use? So you also want to check for the county. Remember, they're not always in a probate court. They can be in circuit court. They can be in any number of different courts. So you need to, that's why I do a Google search to try to get a better idea, well, where might these records be within the county? So courts vary as to who's got what. Sometimes state historical societies and genealogical societies have microfilmed and or digitized and or made available to their local constituents these records. So you might want to check the websites of these other sites to see if they have any probate records. Are you all motivated to go find probate? Sadly, not everybody has one, as I said, but it's worth looking. It's always worth looking.